U.S. Supreme Court today is hearing oral arguments in a case involving the U.S. Environmental Protection Agency and an Idaho couple that's trying to build a house on a vacant piece of property that they bought about 4 years ago. EPA says that the property contains a wetlands, and the couple disputes this. Among other things, the property is sandwiched between two existing homes in an already developed subdivision, and also the property does not contain water except at various times during the year.
This strikes us as a classic property rights issue. There were a couple who wanted to build their dream home next to Priest Lake, and they went through they followed the appropriate rules, the appropriate procedures, and then they were told later on that they were not able to finish building their home. It's really the case of the fact that EPA and the Corps have overreached in their regulatory authority over what waters of the United States are within their jurisdiction to regulate and permit, and what waters are not in their jurisdiction.
So the matter before the court is actually a fairly narrow procedural matter that's in dispute, and that's what the court will be looking at. But NAR, in joining with the other groups in filing the friend of the court brief, it's using the opportunity to talk about some broader issues having to do with regulatory overreach. Can you talk about that?
Yes, that's correct. We felt that this was a fantastic opportunity to really elaborate on some of the broader regulatory and legal implications of the fact that the EPA and the Corps have overreached on lots of these water quality, water permitting, and wetlands issues. One of the main points in the amicus brief talks about regulatory overreach of the Environmental Protection Agency. And that's really been an underlying theme of the EPA since the Clean Water Act was first implemented in the early 70s. The Clean Water Act is very clear about the fact that only waters that are navigable should be regulated and permitted by the EPA and the Corps of Engineers. Since 1972, the EPA has been trying to extend their reach over more and more waters of the U.S. They have done this through regulations. They have done this through guidance documents. Even though two previous Supreme Court cases pushed back against the EPA and the Corps, these agencies continue to try to bring more waters under their control and to expand their reach of the waters of the U.S. That they would like to regulate and permit. Now, of course, everyone knows this affects when you regulate water and use of water, you also regulate the use of land and land use, and that is our primary concern.
I mean, in this particular case here, we're not talking about navigable waters.
Well, that's correct, but that's really the main crux of the problem. The main crux of the issue is the fact that they are trying to expand the definition of navigable into all kinds of areas where we don't think it should be expanded into. Certainly, lakes and rivers and streams are all bodies of water that the EPA should be allowed to regulate. However, other kinds of waters, such as areas that are wet only certain times of the year, areas that are not connected to any other kinds of bodies of water, these are the kinds of waters that the EPA are trying to regulate, and of course this is the area that NAR is pushing back. So the future here of this issue, I think, is as follows. EPA is once again right in the middle of trying to bring more waters under their jurisdiction and under their regulation. They are doing this right now through a proposed guidance document, which from their perspective merely elaborates on current regulations and existing policy. From our perspective, this proposed guidance document brings in more and more waters under their jurisdiction. We have fought back against this proposed guidance document. The EPA says that this guidance document is voluntary and non-binding. But of course, everyone knows that once a guidance document is proposed, once it's finalized and distributed out throughout the country, it becomes the law of the land.
So, on the case itself, once, without going into a lot of detail about what's going to happen next, but once the Supreme Court hears the oral arguments,
right,
what typically happens, and also beyond that, what can NAR members expect with regard to this issue coming up in the next year or so?
The oral arguments were today, and typically what happens, these decisions aren't made at the Supreme Court overnight. They generally take anywhere from 1 month to 6 months. The real question here is, how will a decision affect realtors, clients, and homeowners? A decision for the Sacketts, NAR believes, would strengthen property rights, would certainly strengthen the ability of homeowners and small businesses to fight back against EPA regulatory overreach, as well as allow them to review these decisions on a regular basis. A decision against the Sacketts, we believe, would be would additionally allow EPA to move forward with additional regulations of all different waters of the U.S. above and beyond what is already spelled out in